For 4 weeks, prosecutors in the Casey Anthony murder trial have held jurors and viewers captivated with their experts in the stunning details about possibly what and, more importantly, who killed 2-year-old Caylee Anthony. Today, the prosecution finished making their case, but Anthony's defense team fired back shortly after, asking for an acquittal. The defense will begin presenting their side tomorrow. So now I want to turn to Bernstein, who is a criminal defense attorney and a former prosecutor. You've certainly seen both sides. The judge today denied the defense's request for this acquittal. But listen with me to what the judge said, and then we'll talk a little bit more about that.
The court specifically finds that the state has presented substantial, competent evidence for this jury, who is the trier of fact in this particular case, to decide this particular issue.
So let me repeat that for you. Chief Judge Perry said the state presented substantial, competent evidence. It was almost as if the judge was giving jurors some insight into his opinion. Don't you think? I mean, what's your take on that?
The legal ear says no to that, actually.
Okay,
and this is what happens is everybody's dying to know with this case, you know, what does this mean? Really what he meant was, this is a standard motion almost in every case where the defense says there wasn't enough to even make it to a jury. You, judge, decide. The judge say no. There's substantial, competent evidence to keep the trial going. He didn't say to warrant, you know, to say she's actually going to be convicted. So we're at this stage, and what he really was interesting today, and why everybody's got to keep tuning into this trial, is the talk about circumstantial evidence and the weight of that, because that is what the state's case was really about.
Well, I'm glad you brought up the evidence, because, I mean, the assistant state attorney says the duct tape, the chloroform, just to name a few here, Anthony's car trunk, the searches on her home computer for chloroform and neck breaking, her tattoo. They say, the prosecutors say, that all of this points to her guilt. Do you think that they've proved their case beyond a reasonable doubt?
Well, that is all interesting evidence if someone had seen it. Had it been direct evidence, I saw Casey put the tape on her. That's not what it is. It's circumstantial evidence. And what the judge talked about earlier today is something in law that, as a defense attorney, I argue a lot to juries, which is when the case is based on circumstantial evidence, it's not just enough to, you're inferring something, and so you usually have to exclude any other reasonable explanation. And that's why Jose Baez's, the defense attorney's, opening argument now is kicking into play.
So, just very quickly, tomorrow the defense will start making their case. What should that strategy be then? They've already laid out what they say happened, that it was an accidental drowning in the backyard pool.
And now they have to back that up, and they're going to back that up by probably, I can't see how they're going to get around the mother not testifying. She's going to have to be in there and talk about what that explosive things that we heard for the first time in opening about the supposed sexual abuse in the family, explaining why she lied consistently, and then showing how it could be that the child had an accidental death.
Everybody is wondering if Casey Anthony is going to take the stand. If you were Jose Baez, would you put her on?
I think he has no choice. By what he said in the opening, he led to it, because who else? So far, the parents denied any sexual abuse in the family. He has got to explain to this jury why, by admission, Casey, you know, she lied over and over and over. So why is it, should they believe her now? Mm-hmm. And that is a tough road, but it's one where I know everybody's dying to make a decision now. We have to hold on.
And no doubt on cross-examination, you would bet that the prosecutors would try and trip her up in a lie, because that's apparently what she's known for, at least in the courtroom.
Exactly, and that's one of a prosecutor. When I was a prosecutor, you know, folks who lied to try to get hold of them and dance them through the lies was my favorite.
Well, that sounds fun. Listen, we're going to talk with you much more about this coming up in our next hour, so you'll stick around for us, right? Okay, good. An hour.